Greetings. I am Sister Tabitha Brown, and I am going to answer questions about will have a will as part of the I Will campaign assessment. Question number one: what happens if I do not have a will? If you die without a will, the state or jurisdiction's law in which you reside at the time of your death determines how your assets will be distributed according to intestate succession or probate. The laws generally favor close relatives and spouses, being spouses, children, grandchildren, if none, then parents, siblings, nieces, nephews, etc. This means that an individual, relative, friend, or creditor would have to voluntarily petition the court to open your estate. They would ask the court to appoint a personal representative and issue letters of administration in order to wind up the affairs of the individual who died without a will. Typically, under an insurance bond, since there is no will, and under the supervision of the court. And after all valid debts are paid, distribution would be made according to intestate succession, those close relatives named earlier. In many instances, family members are overwhelmed and intimidated by the intestate probate process when there is no will. And they may go years, even generations, without administering an estate or as long as possible until it is absolutely necessary, i.e., to avoid or in order to sell the property or to avoid a tax sale, to maintain the property and make structural repairs, to refinance, or to rent the property. Again, this is in response to what happens if I don't have a will. The second question: do your debts die with you? No, your debts do not die with you, but they are paid out of your estate, meaning all of the property, money, and goods that you own at the time of your death will go to pay your debts. Your survivors and beneficiaries may not be personally responsible for your debts unless they were joint account holders, co-signers, or otherwise required by law. In some states, spouses are responsible for their spouse's debt if accumulated during marriage. Federal student loans are one of the only types of debt that are forgiven at death. Again, that is in response to do your debts die with you? The third question: how will a will protect minors, or how does a will protect minors? A will can protect minors and dependents of any age, those with special needs, in several ways. First, a will can name a guardian or guardians to care for the minor or dependent if the parent is unable to do so. Also, a trust can be established in the will and distribute the minor's inheritance at specific ages or milestones, and for purposes of education, professional training, healthcare, welfare, etc. Additional specifications and contingencies like lifestyle and responsible behavior can be established in a trust. Again, how does a will protect minors? The next question is: what's more important, a will or to have a trust? Whether a will or a trust applies depends on your specific needs and goals. A will is usually sufficient for simple estates and straightforward wishes. A trust may be better for larger estates with multiple properties, assets, and contingencies. A trust may be helpful for asset complexity, like heir property and timeshares, for blended families, or those with dependents who have special needs. properties in a different states, and a trust can provide asset protection. In many cases, a will and a trust can complement each other, and it is advisable to have both. Again, that was what's more important, a will or a trust. The fifth and final question is, will the trust protect me from creditors during my lifetime and after my lifetime? Certain trusts can protect assets or can provide asset protection from creditors during and after your lifetime. With an irrevocable trust, the guarantor or grantor gives up control of assets, cannot make changes easily to the irrevocable trust once it is established. The grantor receives tax benefits and protection from creditors and legal judgments. With an revocable living trust or revocable trust, the grantor retains control of the assets and can change the trust anytime. One can add beneficiaries and change how assets are managed or distributed with a revocable living trust. While the grantor's estate will avoid probate, and a revocable trust can protect assets from the creditors of heirs, compared to adding heirs or joint owners to assets, which is highly not recommended that we do. For example, adding children or beneficiaries to a deed, which is not typically recommended. The assets in a revocable living trust are still considered part of the grantor's estate for tax and legal purposes. Again, that's answering the question, will the trust protect me from creditors during my lifetime and after my lifetime? Thank you very much, and thank you for participating in the I Will campaign assessment.